Yes, good morning.
Good morning, Your Lordship.
Good morning. Good morning, viewers.
Yes, start. For supplementary clauses under the heading for order, media number 1, MA number 227 of Mr. Ravi Narayan Mukherjee for the applicant, Mr. Sandeep Kumar Verma, Mr. Alok Lal for the respondents.
In this case, my application for reducing additional evidence is on record. That has been placed before a lordship for hearing.
What is the additional evidence which you want to bring on record?
This additional evidence is that after the award, the claimant executed the discharge voucher, giving full and final discharge against the claim and award passed by the insurance company. Thereafter, in my respectful submission, whether after giving a full and final discharge to that effect, whether an appeal disputing the quantum can be raised when the amount has been paid as per the decision of the Honorable Supreme Court passed in Sarla Verma and Pranay Shetty.
But Sarla Verma and Pranay Shetty says that after receiving the amount, you cannot.
No, it is not that. It is not that. The computation is on the basis of the set formula set decided by the Honorable High Court. So
That we will decide later on whether, let us see whether this application has got any relevance or not.
yes, that may be seen. And in that connection, Madam, I would be relying upon some of the judgments of our own High Court and the Honorable
Yes.
Supreme Court, whether
Yes.
in such cases, of course, after giving a due discharge, the claim is still subsist or not.
Yes, give the case numbers which you want to
But
rely.
the first in this case would be of the on our own High Court. Of course, that was the in at the time when this was a part of.
You give me first the judgment of the Honorable Supreme Court.
Yes, Honorable Supreme Court, Your Lordship, that is reported in uh, well, that is with regard to I am having the copy from the Supreme today, but the citations are uh, 2006
2006
9 Supreme
9 Supreme today.
Supreme today 143. The citation would be National Insurance Company Limited versus NIPA Exports.
Which export?
NIPA NIPHA.
Yes.
And the other one would be reported in AIR 1999 Supreme Court 3027.
AIR 1999 3027 SC.
Supreme Court, that is United India Insurance Company Limited versus
Yes, United India Insurance.
Ajmer Singh Cotton and General Mills Limited. And the other would be again 2015 Volume 2 SCC,
2015.
Volume 2 SCC,
Yes.
page 424, New India Assurance Company Limited versus Genius Power Infrastructure Limited.
Which power?
Genius Power, Genus, GENUS, Genus.
Okay.
And the
Now,
other one would be exactly on this issue, Your Lordship, passed by the a bench of this honorable court at by in reported in 1998 volume 2 PLGR page 138. I repeat, 1998 volume 2 PLGR page 138, Ignitia Kujur and others versus National Insurance Company Limited, passed by a bench of this honorable court Of course, it was a single judge or a learned single judge, but the issues are the same. If this practice is allowed, then there would be no end for the litigation, because here they have given a discharge voucher which is on record, full and final discharge of this claim against the insurance company in the claim. Now, whether after accepting the amount as full and final, I do not know how and why they have entered in the court record without prejudice. So the claimant is taking two stands at two different places. So therefore, in my respectful submission, this document which is on record needs to be considered. And so far the enhancement part is concerned, my lord, as I have informed my learned friend who was attending the court yesterday, that some judgment has been relied by my learned friend on the point of whether the claim can be raised. Though in that case, I do not know how that judgment which was relied upon by my friend, would help in this. Let him submit. I'll answer to that.
Yes, what is the judgment you are referring, Mr. Mukherjee? Unmute your. Unmute yourself, Mr. Mukherjee. Unmute yourself.
Now, the conduct, after he finishes, I'll show the conduct of the petition claimant. How he has proceeded the claim application. That would also be relevant from the record. I'll show by date, but by dates. If my lord permit, I'll show the date. My lord, can I have a...
Just a minute, let me hear.
Yes. After Mukherjee finishes, I'll...
My lord, in this matter, my lord, I want to your attention before the page number 31 of lower court record. In this lower court record, at the time of receiving of the amount, the claimant already noted down that she is receiving the amount without prejudice to her right and claim. Firstly.
Okay.
Secondly, my lord, this appeal has been filed on 10/5/2016 and registered on 11/5/2016, whereas this claim payment has been made and received by the appellant on 26/5/2016. And honorable, this decision by the Supreme Court, my lord, M.R. Meena Pavaria and others versus Ashraf Ali, wherein your lordship kindly see the para 13 of this, it is clearly stated. It is clearly stated. I am just going through the para 13 of this decision. Now, so far as the submission on behalf of the Union of India, that in the execution proceeding, the claimants accepted the amount due and payable under the informed judgment and order, and accept the same as a full and final settlement. Thereafter, the claimants ought not to have preferred appeal for enhancement of the compensation is concerned. The aforesaid cannot be accepted. The claimants are entitled to just compensation merely because of in the execution proceeding, they might have accepted the amount as awarded by the High Court may as a full and final settlement, it and shall not preclude them claiming the enhanced amount of the compensation which they as such are held to be entitled to as such. The Motor Vehicles Act is benevolent act as observed herein above. The claimants are entitled just compensation, and as such the Union of India ought not to have taken such plea and defense. Below the 168 clearly says just compensation. And for just compensation, your lordship, I have submitted another decision wherein this is FE 59/2001 decision, in wherein it has clearly stated that tribunal and court have empowered to give the more than the claim amount, enhance the more than the claim amount. So, lordship, there only a letter which was received after filing of the appeal. It is not tenable for to entertain at the IA petition, because your lordship have got empower to enhance the compensation for under section 168 for just compensation. So that's why lordship my submission that IA is not tenable and liable to be dismissed.
NIPA export 2006 volume 9 Supreme Today 143 parallel Kojis. Find the parallel citation. And AIR 99 Supreme Court 3027. February. So, 1998 volume 2 PLGR. Yes, Mr. Lal. Mr. Lal,
Yes, Your Lordship.
you have argued that this claim application is not maintainable.
Yes.
Argue on order 41 rule 27.
As because the document,
Why this needs to, why this application, why this document you need to exhibit?
this document is necessary
He's,
as because
he's not denying this. He's not denying this document. Mr. Mukherjee, are you denying this document?
Simultaneously, both the documents has been executed. In the order sheet, I have noted. I am not denying.
You
Yes,
are not.
I am not denying.
He's not denying this. And what is the, see, the principle is, without this document, if a judgment can be passed in a proper manner, then it is not necessary to adduce additional evidence.
in that case, my lord, then in that connection, my lord, the though I have leveled it out of 41 rule 27, then this document, there was no other way for me to bring this document on record prior to the before the appeal. Therefore, by way of bringing it as evidence, I have put it on record. So my leveling may be changed. The leveling may be changed. The labeling of the
Now come to the merits.
yes, I'm coming to the merit now. Now kindly come
No,
to
your merits. It is the appeal of the appellant. Let's see.
yes.
Yes, Mr. Mukherjee, what is the merits?
My lord, in this, my lord, my humble submission that the deceased was constable at the time of death, accident, and died in the age of, my lord, 37 only, leaving behind her widow, 34 aged, and two daughters of 11 years and 3 years only. And at the time of when he was in duty as a constable of the JAB. Now the compensation has been calculated in overlooking the future benefit prospects and also the dependency, the age. And in this regard, my lord, the appellant already exhibited several documents, and some of the documents supports the promotion because similar type of officers were promoted in the higher rank at the time of exhibit. And thirdly, my lord, only the amount for compensation of funeral and others is too much lower side in the
No,
sense of
future prospect has not been granted.
not been granted, and not only benefit for the dependency, there or that also not been guaranteed, and thirdly, when we look, interest is in a lower side, and also the interest has been given from the date of admission of the case, because the disease died in the year 2002, case filed in the year 2018, and case admitted on 2014. So, Milord, in this regard, my humble submission, the interest should be enhanced also, and simultaneously interest should be from the date of death or date of filing of this application, not the date of admission. It is in the year 2014. So the entire matter is depends that computation and beneficiary benefit from the dependency and others interest matter. These honorable lower court have overlooked all these points and given a very lesser amount than the claim amount. And your lordship have not, after finding that genuinity, can enhance more than the claim amount. As per the decision I have already submitted before
No,
your
no.
lordship.
See, case was admitted when?
Case case was admitted on 16. Case case admitted, just my lord.
Well, may I provide the entire dates?
Yes,
I
go
mean,
ahead.
yes. Claim was filed on 3rd December 2008. On
Yes.
16/12/2008, time was prayed for filing the deficit court fees. On 5/11/2019, we have appeared. On
5/11.
2009, we have appeared. This would be apparent from the entire order sheet. I have noted out of the entire order sheet.
Yes.
And on 22/8/2009, some order was passed directing the claimants to provide certain documents. And again on 8/3/2013, 8/3/2013, the claimant was directed to file the FIR and other documents. In the year 2013, 3/5/2013, claim under 140 was filed. Now,
Claim under 140 was filed in 2008 itself.
2013.
No, my lord, it is wrong.
It
Oh,
was
sorry, it
filed
was
in
decided. Sorry, it was decided. Oh, no, sorry, it was decided. 3/5/13, the claim application of 140 was decided. Now, I stand corrected. On 9/12/2013, deficit court fees of rupees 7,000 was filed. 5/3/14, application under 166 was admitted. In terms of order dated 1/9/14, no steps were taken by the claimant. Again, till 27/5/2015, no steps were taken. Issues were framed on 5/5/15. So from 2018 till 2015, the claimant was not taking any steps for make the case ready, make the case ready. That would be apparent from the LCR also. I have noted it from the LCR. Now, subject to answer my completing of the submission by my learned friend, I'll reply other things.
No, he has submitted already.
Now,
What
my
about
very-
future prospect? Future
my
prospect
learned
granted.
friend is very conveniently submitting without perhaps going through the record that future prospect has not been granted. Kindly come to Annexure 3. Sorry, Exhibit 3. That is the salary slip.
Yes.
that has been discussed in paragraph 13 of the award. I may read for for convenience of your lordship, my lord. As held above,
Yes.
the deceased was earning rupees 7,020 or rounded up to 7,000 per month. An addition of 50% in actual salary is also applicable in computation of compensation. Therefore, this Pranay Sethi has been applied. Now, multiplier has been 15 as because he was 37 years. That is also correct. No, so far the grant of interest is concerned, because of their laches and negligence, the insurance company cannot be saddled with the interest.
Deduction, how much?
Deduction is mm, 12 deduction one third. Deduction one third. That is also correct.
How many? One, two, three, one third.
One third. Now, the judgment by Learned Friend was relying specifically on paragraph 13, ignoring the condition in which that judgment was passed. In that case, the ratio of pronunciative future prospects were not taken into consideration. Therefore, the Honorable Supreme Court has taken a view that in such circumstances,
So
the
far as so far as non-pecuniary loss is concerned, it is only 25,000.
only that, only to that consortium part, only to that extent, nothing beyond that, nothing beyond that.
That means 45,000 more.
No, it has been awarded. Just 25,000 has
45,000
been paid.
is paid.
25,000 has been paid.
But so
Conventional 25,000 has been paid.
okay. Let us see the salary slip
Exhibit 3 may kindly be seen.
exhibit.
3, which is their exhibited document.
It is of the year. Death is of the year.
2002, yeah.
October 2002, salary slip is 2002, October 2002.
2000.
2. He met with an accident on
Yes.
27/10/2002.
Okay. 7028.
1,000. 28 rupees has been only been deducted for convenience.
Yes, Mr. Mukherjee.
Milord,
Where
on
is the flaw?
also,
Where is the flaw?
also, Milord,
What is the fault in the judgment? Future prospect has
Milord,
been avoided.
the future prospects has not been allowed as per the exhibits of salary slip of
Oh,
other.
Mr. Mukherjee, future prospect now has been realized. Pranay Shetty case is there.
I'm sorry.
You
I am sorry, Milord.
Yes. Mr. Mukherjee, we cannot deviate beyond Pranay Shetty. Pranay Shetty has laid down the formula as to how to calculate future prospect. It says if a person is uh, permanently employed and salaried in job, 30% of the and he's aged about below 40 years, that means 50% of the present salary to be added. So that has been done.
No, my lord, in this regard, not only that thing, if your lordship will see that the pecuniary losses and other interest matter and everything, that should be
What
considered
interest?
by the
What interest?
that
Come
interest
specifically.
interest is in a lower side, and secondly also interest from the date of filing of the appeal, not from the date of admission, as
No, no,
because
no. He has pointed out that he never took steps for
my lord,
disposal of his appeal.
being a poor widow lady, she's an illiterate lady, is not in a
That cannot
position
be
to
allowed.
attend.
That
And then
cannot be allowed.
not only 1 or 2 dates is she unable to attend, but simultaneously after getting 50,000, she's taken all the steps accordingly as per the order of the Honorable Lower Court. So they have
Just,
also,
just a minute. The death is of 2002.
my lord,
This lady got compassionate appointment or not?
no amount has been granted to her.
This lady got compassionate appointment or not?
No, this lady not got any compensation appointment till today.
She,
She's a housewife. Her daughter
no,
after get her
she has,
daughter, her elder daughter after getting major, she got an apartment later on.
when, when?
Uh, she was 11 at the time of death, 13 in the year 2017 or 16, most probably.
She has got appointment.
Exact date I don't know, Milord. Exactly. Later on, she got the compensatory job for the year.
See, Mr. Bogaji, from 2008 to 2011, you had not complied the order which the court had directed you to comply.
Most of the dates she
No,
have
no, no.
taken the steps.
Mr. Mukherjee, if the court directs you to do a particular act and you simply put in your attendance slip and you don't comply that order by not performing the act, it cannot be said that you are vigilant.
Lord, in this regard, as because the lower court file is not with me just now, I'll submit that particular date. The appellant have taken steps as per the possibility, because financially she was not strong, and for shocking and everything, she most probably not complied on the date fixed for by the Honorable Lower Court. So that should be from the date of admission at least, my lord.
So from the date of admission, it has been granted.
So, sorry, not admission, date of filing of the case, my lord.
No, you file
And
everything.
also rate of the interest is also very low. It
How
should
much?
be 10 to 12% per annum instead of 7%, which has been allowed by the court.
Well, one more thing I would like to point out, that death is of 2002. The claim application is filed by 2008.
So you can't take this plea.
I can't take plea because of
the statute gives this liberty to file it.
Statute gives the liberty.
20 years also.
Yes, statute gives the liberty, but now there are certain judgments also that which has come that it should be at the earliest. Though no limitation is prescribed, it should be at the earliest.
You have not complied on the previous orders. Yes, anything more?
Well, with
Only
regard
me,
to judgment which my learned
my lord,
friends will decide upon, only
my
paragraph
hum,
30 will not suffice. The conditions in which that judgment was situation was passed, that is also to be seen.
my lord,
Previous paragraph.
my humble submission, my lord, being a illiterate lady and a poor lady, she was not in a position to comply the order of the lower court immediately. But she tried her best because she is illiterate. She have got no knowledge about the law and everything. She filed the case after 6 years of the death. So your lordship will see the actual mental position of the lady was a very had, and that can be excused by the lordship to file the comply the order of the lower court in not in a time. So it can be ignored by your lordship, and interest should be from the date of filing of this case at least,
Okay, judgment reserved.
my lord.
कितने देर तक सांस लेने की जरूरत है? तुरंत से दो लगातार है। नहीं, ये तुरंत से यही है। This is the first one.
From Delhi causes under the heading for orders, serial number 1, MA number 328 of 50, Mr. Alok Lal for appellant, Mr. MB Lal for respondent.
But in this case, in terms of order dated 30th of November 2021, the notices were directed to be issued by speed post and ordinary process, and in pursuant thereto, on 6/12/2010, we have taken the steps. But I'm not aware of the status of the notice of the owner. He is the most relevant person to answer the.
Fresh notice to be issued upon respondent number 1, 2, and 3 requisites a present and correct address.
Appearing, Your Lordship.
My lord, respondent claimant want to have we appeared, my lord.
1 and 2 you have appeared.
My lord.
The service report is that you have pata nahi chala. Fresh notice on respondent number 3, ordinary process, correct and present address, requisites 4 weeks.
But the return copy may be utilized if available, Your Lordship.
It's a registered return copy, let it be there.
Obliged.
Serial number 2, MA number 468 of 50, Mr. Manish Kumar for appellant.
My lords, in this case, notice was issued to respond number 2 on 3rd January, my lord, this year. Although she is not, my lords, required in this case, my lord.
Who is respondent number 2?
She is the owner, my lords. We have the claim, if at all, against the respondent number 1, against whom it has been validly deemed to be have been served, my lords.
So you have no claim against respondent number 2.
No, my lords.
Together, the counsel for the appellant submits that they have no claim against the respondent number 2 in this appeal. Full stop. Next para. Considering his submission, this court feels that it will not be fruitful to direct the appellant to take fresh steps for issuance of notice upon respondent number 2. Full stop. It is not necessary to full stop. It is not necessary to issue fresh notice to respondent number 2, the owner of the vehicle, the owner of the vehicle. Full stop. Yes, this case can go under the heading for admission.
Yes, my lords.
Delay.
No, my lords. I think there is no delay now. We had filed one IA for stay, my lords, and that will subject to
Let
the
this go under the heading for admission.
obliged.
Serial number 3, MA number 515, Mr. Arvind Kumar Lal for appellant.
My lord, in this case, earlier notices were issued. I'm not aware whether it has been validly served or not.
But I am appearing for respondent number 5, but my learned friend has not supplied me the copy of the award. Only the notices were which memo of appeal was sent.
I have already given. That was
Sir,
attached. Perhaps
Sir,
due to mistake, it
I'm
might
giving
be.
you this is your attachment. This is the last page, and this is the registered letter which I have got.
Okay, then I will supply you the copy. जब अवार्ड हुआ तो आपको ऐसी कॉपी होना भी चाहिए.
Certainly होना चाहिए मेरे पास. ठीक है. Okay, आप मत दीजिए, हम मंगवा लेंगे. Leave
I
it.
will give.
I'll get it collected from my bank.
Side. Certainly, I will
Don't
cooperate.
worry.
Fresh
Don't worry, I'll
notice,
get it collected from my bank.
fresh notice to respondent number 3. Ordinary process.
My lord.
Requisites.
Serial number 4, MA number 21016, Mr. Amresh Kumar for appellant.
In this appeal, Your Lordship, notices has been issued on 21/10/2016, Your Lordship. Insurance company has appeared and 2 other counsels' name is appearing in the court this time. Don't know.
My lord, I am appearing on behalf of the claimant 1 to 4.
Who is 5?
5 is the driver, Your Lordship. It is not so important, but 6 is important. Your Lordship, the honor.
It has.
6 has not appeared in the court below also, my lord.
Respondent number 5 is the driver. Full stop. No notice need be issued to the driver in this case in view of the relief sought for in this appeal. Full stop. Next para. Office has reported. It has been reported that respondent number 6 has died.
6 has not appeared in the court below also.
6 is not that, Your Lordship. The father, Mahadev Mishra, is died, Your Lordship. In the judgment, it will come.
In his place, my lord, the honor, the son was made.
Respondent number 6 is dead. It has come in the office note dated 15/3/2022. Counsel for the appellant prays for some adjournment. Prayer allowed. This is adjourned.
Obliged.
My lord, it may be listed because since it is of 2003 claim, my lord, they have got this stay order. 6 has not appeared in the court below also.
So show me any
Court below is
judgment.
appeared here.
Show me any
No,
judgment if a party does not appear in the lowest court. In the subsequent, he is not a necessary party in the subsequent proceeding. Show me any judgment.
Some time may be given, my lord.
However, respondent number 6 is dead.
Yeah.
Yes, next.
Serial number 5, MA number
Obliged.
716, Mr. Sagar Kumar Naik for the appellant, Mr. Mukesh Kumar, Mr. Pradeep Kumar for respondent.
My lord, earlier steps were taken for service of notice, but my respondent number 2 owner has appeared. But my lord, insurance company till date, my lord, has not put their appearance.
Respondent number 2 is the owner.
Yes, my lord, he has already appeared.
For respondent number 2.
Who is respondent number 1?
Insurance company, my lord.
Notice validly served. And
That,
proceed ex parte. I will proceed ex parte against the insurance company if the notice is validly served. SR, service reports. Okay. Where is respondent number 1? Service report on respondent number 1. Who appears for the national insurance?
Usual, I do appear.
Mr. Alok Lal accepts notice on behalf of respondent number 1. Let name of Mr. Alok Lal appear in the cause list.
Mother, if by learned friend shall be heavily organized to my learned friend if he supplies me the copy tomorrow.
Yes, Mr. Laik, learned advocate Mr. S. K. Laik will serve a copy of the appeal to Mr. Alok Lal. Mr. Lal, 13 days delay.
Delay may be controlled, Mother. Delay.
Aye. Heard Mr. S. K. Laik. Where is Mr. Laik?
yes, my lord.
Heard Mr. S. K. Laik. It's IA. He prays to condone the delay of 13 days in filing this appeal. Full stop. After hearing the counsel, I have gone through the application. Full stop. The grounds have been mentioned in paragraph 5. Para 2, 3, 4, and 5. Considering the submission, IA allowed delay condoned list this case under the heading for admission.
Mr. I give it tomorrow 2 copies.
Next.
Serial number 6, MA number 11070, Mr. Rajiv Anand, Mr. Ashok Kumar Sinha number 4, for appellant Mr. Bharti Kumari, and Ms.
I am appearing, Lordship. I am appearing this case, Lordship.
Yes. Yes.
Limitation for this, Lordship, 210 days, Lordship.
210 days.
Yes, Lordship. And regarding delay, Lordship, a statement made in paragraph 4 and 5, Lordship.
Who is respondent number 1?
The respondent number is private, Lordship. Lal Dev Sharma.
Who is he? What is his status? What is his status in this case?
Owner of the offending vehicle, my lord. He's appeared in the court below.
Any right to recovery given?
No. No, my lord.
Because since no right to recovery has been given to the insurance company, comma, to recover the amount from the owner, comma, it will be useless to issue notice, fresh notice, upon the respondent number 1. First. Next, brother. Delay of how many days?
210 days.
5-4, or delay has already been condoned. Is this case under the heading for admission?
Obliged, Lordship.
Serial number 7, amendment number 137 of 70. This is Mr. Yogesh Modi for appellant, Mr. Alok Dal, Mr. Shubham Gautam for respondent.
IA is for limitation of condoning the delay of 319 days, my lord. But the petitioner was declared 50% permanent disability with brain injury, my lords, and he was under treatment even after the passing of the judgment prior to filing of this appeal, my lords.
Yes.
Annex the medical bills and prescriptions.
IA number 8007 of 2019. Let's start. The delay, there's a delay of 319 days in filing this appeal. First of the next one. Counsel for the appellant suffers that the appellant was injured, was suffering and from physical ailment, and was also under regular treatment after the accident. He submits that even after the judgment was passed, he was under regular treatment and suffered brain injury, as he suffered brain injury. First up, the counsel for the appellant relies upon the several medical documents annexed along with this IA. Next paragraph. The counsel opposes, the opposite party, counsel for the opposite party opposes. Full stop. Next, but after going through the application, interlocutory application, and after going through the medical records, I find that sufficient ground has been shown to condone the delay, as the petitioner was undergoing treatment in Jamshedpur, Kolkata, New Delhi, and Bangalore. Full stop. The delay of so and so days is condoned. Is this case under the heading for admission?
Serial number 8, amendment number 177 of 70, Mr. DC for appellant, Mr. SP Rao, Mr. Pankaj Kumar for respondent.
My lords, I'm sorry to my lords intervene. My lords, in this matter, Pankaj Kumar, my lord, has been assigned with this matter, and all of a sudden, my lord, he is not available, as he has gone, my lord, for उनकी बेटी का एडमिशन है मणिपाल में हजूर. So उनको पता नहीं था. Today morning he has informed me, my lords, that he is out of station.
But what is this?
Lordship, this is the case. This is was a rooftop passenger, your lordship. Number 1 point. And the second is that the in conventional head 3,25,000 has been paid.
Why under the heading for orders?
Last occasion notices were issued upon respondent 1 to 8. Order dated 27/21, your lordship.
One, 2, and 5 appeared. Who is 1, 2, and 5?
One is the wife of the deceased, 2 is his son,
And 5 appeared. And the owner also appeared.
yes, lordship. Lordship, up to 7.
Let's discuss under the heading for admission.
Lordship, 1 to 7, they are from the same family, they are the dependents, your lordship. So,
Okay,
one,
it's complete, more or less. Who is appearing? Mr. Abhay Tiwari. Let's discuss under the heading for admission, as the parties have already appeared.
Serial number 9, amendment number 190 of 70, Mr. Chandrajit Mukherjee, Mr. Anjali Kumar for appellant, Mr. Nikhil Ranjan for respondent.
May I please, your lordship? In this matter, notices were issued, lordship, on 7/11/19. Claimant has appeared in this matter, your lordship. We are also praying for pay and right to recovery in this matter.
Who is the owner?
Owner, it was ex parte against the owner even in the court below, your lordship.
Maybe. So that doesn't mean that this case will be also proceed ex parte against him without even issuing a notice.
Notices were issued on 7/11/19, Your Lordship. And today it has come on IA for stay.
Stay. Why stay?
Execution proceeding is going on, Your Lordship, and the notices were issued in the on 18/2/2021 itself.
Find out the correct address of respondent number 3.
Lordship.
And my lord, the copy of the IA application has not been served.
I'll serve it. If it has not been served, I'll serve it.
Current and present address notice requisites 4 weeks ordinary purpose.
Obliged.
Serial number 10, MA number 1. Serial number 10, MA number 195 of 17. Mr. Vijay Kumar Sharma for appellant. Mr. DC Jam, Mr. Abresh Kumar for respondent.
May appeal, Your Lordship. The injury case, Your Lordship. The instant appeal is filed for the enhancement, Your Lordship, and the further limitation, the bill of the 210 days delay, Your Lordship. I have explained the delay, para 3, 4, and 5, Your Lordship.
Yes, insurance company.
Lordship, arising out of the same matter, we have also preferred an appeal that is numbered as MA 577 2016.
No, there is a delay of 201 days. What do you have to say in this? Okay. Are the counsel for the appellants and the counsel appearing on behalf of the insurance company? There is a delay of 210 days. Full stop. To condone that said delay. And this application IA 2815 has been filed by the appellants. The reasons have been mentioned in paragraph 3, 4, 5. Full stop. Being satisfied with the reasons and inclined to allow this IA, the delay stands condoned. Full stop. Main here. Is this case along with
MA 577 of 2016.
577 of 2016.
Obliged.
Serial number 11, MA number 209.
No, Your Lordship. So far as it's Your Lordship, on 26 2021,
Your Lordship,
2,70,600
senior counsel is arguing in another court, so I pray for short passover.
As NPA. No, Your Lordship.
Yes.
Yes, sir.
Your Lordship, senior learned counsel is arguing in another court, so I pray for short passover.
For orders, there's no necessity of your senior counsel to appear. Tell me why this is case.
2,70,623, Lordship. Your Lordship.
Yes.
No, Your
Lords, Lordships, there is an IA for condonation of delay, Lords.
Yes.
35 days, and Lords, there is another IA for Lords because there are 4 minors claimants. So Lords, the application has been filed for in respect of claimant number 5, being the father-in-law of the deceased and being the grandfather of the claimants, to be taken as a next friend of guardian ad litem. Now, if your Lordship sees the impugned award, in the cause title also, it is mentioned as the next friend. But by way of abundant caution, this IA has been filed because Lordships, just to give a specific statement before Lordships also, that there is no adversarial interest in regard to matters and controversy between the claimant, because as per the records, Lords.
just tell me one thing.
Yes, Lord.
This application was filed claiming claiming compensation for the death of
Death of one Rajesh Prasad, who happens to be the father. Lord. Death of one.
Rajesh Prasad, definitely.
No, Lord. The death of the mother. Lord. Death of the mother. Death of the mother of the claimants. Rita Devi.
Father was already dead.
Yes, father was already dead. Mother was the housewife. She was working selling vegetables and milk. She died, and for that, Lords, they had filed. The case of the insurance company is, Lords, one thing that there was no permit. It was a dumper, and there was no permit, and he had filed, and we had produced a positive evidence that he had deposited penalty. He was, charged with a penalty and 10,400 rupees and extra 3 in the memo of appeal that was marked as an exhibit before the court below also. And
No, Your Lordship.
that was subsequent to the date of accident.
All the three tractors which has been delivered, not has been appropriated by the Bank of India.
Yes. Yes. What are you saying? Submitting? What are you submitting? Is Mr. Pratish Kumar?
Your Lordships, I'm sorry, Lords, I was mute, so Lordships could not hear it, my submissions. I'm sorry. Lords, this appeal was preferred by the insurance company. Lords, there is a delay of 35 days, and Lords, and a separate IA for claimant number 5 to be taken on record as guardian ad litem.
Who is
Also
appearing
filed.
for the respondent?
Lords, the notices has to go to the respondent, Lords, and we have led positive evidence that there is no permit, because on the date of accident the vehicle was plying without permit, and we had filed a penalty which was imposed by the motor vehicle inspector, and that was subsequent to the date of accident, Lords, which is Annexure 3 before Lordships, and that has been considered by the tribunal also, but did not give any finding as regards the permit aspect issue is concerned.
Notice to 1 to 4 through respondent number 5, and also to respondent number. Who is the owner?
Lords, the owner would be respondent number 6.
Respondent number 6. Ordinary process requisites 3 weeks on both limitation and main matter.
Lords, obliged.
Serial number 12, MN number 221 of 17, Mr. DC Shah for appellate.
Yes.
There is an IA for confirmation of 117 days delay, Your Lordship.
No, whether all the parties have appeared or not.
No. The notice has not issued earlier, Your Lordship.
Notice to respondent number 1, 2, What is the nature of your appeal? Your relief sought for?
Yes, Lordship. Though in this
Owner, against the owner of the vehicle.
yes, Lordship. Right to recovery has been granted.
Right to recovery granted.
Yes, Lordship. In last paragraph, operative part, Your Lordship, plus just above the operative part.
No, just tell me what is the ground in this appeal. That means quantum. If the right of recovery is granted to you, then your case is that he was a gratuitous passenger.
Yes, he was sitting on dollar.
So in the case of gratuitous passenger, you have got the right to recover the amount.
Yes, Lordship.
So then, why should I interfere? I'm dismissing this right away. Mr. Jha,
Yes, Lordship.
I'm dismissing this appeal.
Quantum is also on the lower side, Your Lordship. Quantum is also
Quantum is on the lower side.
lower side. It is most reasonable. 3,58,000.
In a case of death of a 7-year-old child, the Honorable Supreme Court is granting 4 lakh or 5 lakhs.
Lordship, when the appeal was filed, there was some judgments which shows that the insurance company is not liable. That's why this perhaps
In the nature of the appeal which has been filed, in the nature of the relief sought for, I'm inclined to dispose this appeal at this stage itself. There's a delay.
delay of 110 days.
Delay condone, 110 days a year.
117.
Next.
117.
This appeal is at the behest of the insurance company, challenging the award dated so and so, passed by Motor Accidents Claim Tribunal so and so, whereby a sum of rupees 3,58,740 has been awarded to the claimants, along with interest of 6% per annum from the institution. Also, next paragraph. From the appeal and the submission made, I find that the only one ground has been taken in support of the appeal by the insurance company. It is the case of the insurance company that since the deceased was a gratuitous passenger, it is the owner of the vehicle who has to pay the amount of compensation, and no liability could have been fastened upon the insurance company. Next paragraph. After going through the impugned judgment, I find that
in para 6, Your Lordship, that is page 8 of the judgment.
I find that the tribunal, after discussing the evidence, has held that the owner of the vehicle has violated the terms and condition of the insurance policy. And thus, liberty was granted to the insurance company to realize the compensation from the owner of the offending truck, bearing registration number UP 67 1812 1812. First up. The principle of pay and recover, next paragraph. The principle of pay and recover has already been applied by the tribunal and relief has been granted to the insurance company. In that view, this court is of the opinion that the appeal is misconceived. Appeal at the behest of the insurance company is misconceived. This appeal is dismissed. It is reiterated that the insurance company may recover the said amount from the owner of the vehicle.
Statutory amount.
The statutory amount to be refunded to the insurance company. लिख दीजिएगा हाँ.
Lordship, delay was 117 days. By mistake, I said 100.
117 days. Yes.
Serial number 13. MN number 233 of 70. Mr. Manoj Kumar number 2 for appellant.
My lord, one IA is for continuation delay. Delay is about 164 days, my lord. I am claimant, my lord.
You are the claimant. Your claim application dismissed.
No, we have preferred appeal for enhancement, my lord.
Enhancement. This is Workmen's Compensation Act.
Workman Compensation Act, my lord. In this case, my lord, pecuniary loss has been not paid. Love of affection and consortium and funeral expenses has not been paid. And well, the deceased wife died over it was 30 years. And my lord,
this is a Workmen's Compensation Act, Mr. Counsel.
Yes, my lord. And therefore, multiply by 207, my lord, and divide by 26. 50% amount.
Employees Compensation Act. What is the award?
Award, my lord, 6,94,098 rupees.
On what ground you are paying for enhancements?
One round, my lord. Computation, my lord.
What computation is has to be as per the act.
Wages, my lord, 119 rupees, 19 paise per day, whereas he was getting salary 4,000 per month and also allowance 100 per day for food allowance, my lord. And second count, only two rounds. Second count, my lord,
second round,
loss of love and consortium and funeral expenses has not been paid back.
Under which provision of the Employees Compensation Act you are entitled to receive that? Yes, Mr. Counsel. Switch on your video. Switch on your video.
Well, video is my own, my lord.
Yes.
My lord, in this point, I am not ready yet, present, my lord.
Show me. Show me the provision or any judgments.
Only pass of 40 next week, I will, my lord. I try my best to give any judgment, my lord, any judgment.
Issue notice to respondent number 1, 2, 3, and 4, ordinary process requisites for weeks.
Apply.
Serial number 14, serial number 14, MA number 237 of 17, Mr. Nikhil Ranjan for appellant, Mr. Alok Lal for respondent.
My lord, on the last occasion, notices were filed upon OP number 2, the owner of the vehicle. Thrice notices have been issued, my lord.
So,
the right of recovery is there, my lord, so they have prayed for enhancement. So owner's appearance is necessary.
they are not appearing.
My lord, I'm unaware whether the service is sufficient or not. The notices were issued on 23/7/2021.
Not sufficient.
The substituted service?
They have not taken any steps in spite of the order.
My lord, I will take recourse of Order 5, Rule 20, my lord, 21A for paper publication, my lord.
23rd July, this was the order was passed.
2 weeks, just 2 weeks may be granted. I'll file an IA for that, my lord.
The counsel for the appellant submits that
Thrice, my lord.
he wants to take steps of Order 5, Rule 20.
21.
Capital A of the CPC. 20 within bracket 1 dash capital A of the CPC.
My lord.
Prayer allowed.
Compliance, my lord.
Serial number 15, MA number 248 of 17, Mr. Alok Lal for appellant.
But in this case, in terms of order 12/5/10/5/19, the notices were directed to be issued, and we have filed the notice on 4/6/19, but I'm not aware of the status of the notice. Service of report.
Anyone appearing?
Yes, Your Honor.
The notice have been validly served on respondent number 1, 3, and 6. So far as notice notice issued to respondent number 1 to 5 has been validly served. 1 to 6 also. Okay. The notice have been validly, as per the office note, notices have been validly served upon the respondent. We'll stop. Next one, none appears on behalf of the respondents. First up, there is a delay of
62 days.
62 days in filing this appeal. days. 58 days in filing this appeal. The the reasons for delay has been mentioned in paragraph 4 onwards, 4 to 11. 4 to 12. First up, considering the same statement made in the IA, this IA allowed this case under the heading for admission.
Serial number 16, MA number 249 of 17, Mr. Alok Lal for appellant.
But in this case also it does the same thing, Your Lordship. The notices were issued upon S1 1 to 3 in terms of order 9519, and in pursuant thereto we have taken the steps of notice. This was the second attempt of notice on 9519. First was on 17/8/17.
Fresh notice on respondent number 3. With both process requisites 3 weeks. Is there any right to recover, Mr.
No, Your Lordship. No.
Then it is not necessary to issue notice to respondent number 3. What is your ground?
No, there is no, but we are challenging, we are claiming for the right of recovery in this case, as because the issue number 6 with regard to the permit has been discussed. Kindly come to paragraph 12 of the award. I am reading it for your Lordship's convenience. Permit, this issue number 6 is whether the truck number AP 16TX 3575 had a valid and effective permit at the time of accident. उक्त वाद बिंदु के उभय पक्षों के विद्वान अधिवक्ताओं को सुना एवं अभिलेख का उपलब्ध मौखिक दस्तावेजों साक्ष्यों का अभिलेखन किया।
Yes, issued notice to respondent number 3, registered ordinary both process. First up, notice upon respondent number 1 and 2 is deemed to be validly served.
Serial number 17, MA number 253 of 17, Mr. Patish Kumar for appellant.
Okay.
My lords, this is an appeal preferred by the insurance company, my lords. There is an IA for condonation of delay for 21 days, my lords. And my lords, inadvertently, my lords, while filing the memo of appeal, one of the claimant was left out, my lords. So, my lords, and a separate IA has been filed for addition of party, my lords.
The parties have appeared.
No, my lords, notices has to go, my lords.
IA number, addition of parties?
5501.
5501. Okay. Learned counsel appearing on behalf of the appellant submits the due to inadvertence. The name of
Dhananjay
Dhananjay Prasad Singh, son of late Ganesh Prasad Singh, has not been incorporated in the cost title as respondents.
Six capital A should be.
As a respondent due to inadvertence. He submits that Seth Dhananjay Prasad Singh was applicant number 7 before the tribunal, and thus he needs to be impleaded as a party. Next para. Considering his submission, this IA is allowed. Dhananjay Prasad Singh be arrayed as respondent number 6 capital A. Full stop. Counsel for the appellant will make necessary correction in reading within 2 weeks. Full stop. उसके बाद this IA disposed of. Then write on the next the IA on limitation. Issue notice of the limitation in the main matter to the respondents. You are praying for recovery.
Yes, Lord, because there was no premium paid with respect to the laborers in the tractor.
Notice ordinary process to all the respondent. Visits 3 weeks.
Obliged.
Serial number 18, MA number 259 of 70, Mr. Ashutosh Anand for appellant, Mr. Santosh Kumar for respondent.
Malad, before my friend proceeds, Malad, in this case, name of Mr. Santosh Kumar is appearing. He seems to, but he is my junior. So, but I do not think there is any other insurance companies involved.
No, there is no insurance company.
Yes.
You are for the claimant, Mr. Lal.
Yes, Your Lordship.
You are for the claimant.
No, I'm not. I'm for none. I do not know how name of Mr. Santosh Kumar, my friend, is appearing. Therefore, I was wondering whether copies have been served upon him or not. He has replied that he said no copies have been served upon him. We are not concerned in this case. My office is not concerned in this case.
Santosh Kumar is appearing on behalf of.
I am appearing on the respondent number 3, Your Lordship.
Respondent number 3.
Your Lordship.
Yes. What about the other respondents?
Sorry, my lord, I could not check the files.
1 and 2.
My lord, 1 is the claimant.
1 and 2. What is your ground?
My lord, I just upon 2 major grounds, my lord. The first major ground is that the income which has been taken as 12,000 rupees per month is highly exorbitant without any proof, my lord. No, the salary circuit was not proved by reading any evidence. And the second is, and no corresponding CF register, etc. The manner of accident suggests that the insured vehicle, which was the Hiva, it was going uphill, and the motorcycle, there was a head-on collision between the motorcycle and the insured vehicle. These are the 2 major grounds, my lord. Apart from that, my lord, the 25% has been directed towards bachelor, which should be 50%, my lord. The interest is on the higher side, my lord. And towards the unconventional head, higher amount has been granted, more than 70,000, my lord. 1,25,000 has been granted.
Fresh notice to respondent number 1 and 2. Ordinary process requisites 2 weeks.
My lord.
Serial number 19, MA number 269 of 70. Mr. Vishal Kumar Trivedi, Mr. Suman, Mr. Ashutosh Anand for appellant, Mr. Shravan Kumar for responding.
My lord, I am on behalf of respondent.
But who is on behalf of the applicant?
My lord, I am appealing for the appellant, my lord. This is
Yes.
an appeal filed by the owner against the ex parte order, my lord. And the recall petition which was filed, there's a delay of around 407 days in preferring the appeal against the original award.
My lord, yes, my lord, delay is intentional, my lord, and he has suppressed the fact, my lord. Page number 50, my lord. Notice has earlier been issued and received by the appellant, my lord, in compensation matter, my lord.
My lord, let me explain, my lord. Let me explain. Perhaps my friend has not gone through the memo of appeal. Earlier notices were issued. It was not served. And Annexure 3 may be seen at page number 40. Page 40 and 41. 41 is the relevant of the memo of appeal. I have got the certified copy.
Yes.
It says, I am placing page 41. आज तारीख 3/1/2011 को अंदाई सो एंड सो दिए गए नोटिस का मिला सरजीत पहुंचकर अपना तलाश किया। उपरोक्त पार्टी का तलाश करने पर पता चला कि विपक्षी काम की वजह से बाहर गया है, इसलिए एक विगत नोटिस मकान की बाहर दरवाजा में लटकाकर तामील किया। And my lord, thereafter, if lordship may kindly turn to my memo of appeal, the newspaper publication was affected, and the newspaper in which it was affected was unknown newspaper. In fact, I have also heard the name of the newspaper for the first time. This is
Jamshedpur.
My lord, at Jamshedpur.
Aina.
My lord.
In Jamshedpur, all the newspaper notices are published in Aina, which has got no publication.
Chamakta Aina.
Yes.
My lord, now so far as merits of the case is concerned,
Just a minute. Just a minute. Have you filed any application for recall?
My lord, order 9/13, this is the improved order also on 20/4/2017, annex page number 47, annex 5.
Yes.
My lord, the relevant would be the court has not gone into the aspect whether the notice was properly served or not. With all due respect, my lord, I must place page number internal. It starts from internal page number 4.
This order is also challenged.
My lord, at page number 50.
Read that.
Heard the learned counsel of both the sides and pursued the case record. From pursuit of the case record of complaint case number 7 to transfer that OPs of the institute are applicant of so-and-so. And the sole OP of the said case, that is Ramesh Kumar Sharma, with the owner of so-and-so. The applicant Renuka Devi, so-and-so, have filed company case number and case was admitted on so-and-so. In the meantime, the case record has been transferred to the court of so-and-so. After receiving the record, notice has been issued against the OP on so-and-so, and case record was fixed for awaiting the SR. SR of the summons has been issued and tagged with the case record so-and-so. Thereafter, the learned DJ1 passed an order on so-and-so that SR has received, but the OP has not appeared yet. Applicant is right to take further. Answer, Malur.
Mr. Counsel, you have not challenged this order. You have only preferred an appeal against the main.
Malur, the memo of appeal, because this was filed by some other counsel, I would, as per me, my lord, in the prayer portion, there are two orders.
It has been deleted. So now, yes, you can maintain an appeal. You can maintain.
Malur, even otherwise, the appeal is maintainable against the party.
As it is, I will read if there is any wrong in the judgment.
Mallards, with regard to the error of the judgment, Mallards.
Yes.
The first is with regard to whether the notice was properly served or not.
No, that can't be. That can't be.
The interim order always merges with the final award, Mallards.
No, this is not an interim order. This is not an interim order.
Not this. Even D was this order 9/13 award, Mallards. Order, Mallards. The interim order by which ex parte proceedings have been ordered against me merges with the final award. So even while assailing the final award, I can always challenge the same.
No, when you have already filed a petition under order 9/13, that was dismissed and you have not challenged. Sorry, I'll not allow you. Now come to the award. What is the ground?
My lord, so far the award is concerned, my lords. This is also based upon the erroneous aspect with regard to, I may permitted to just place two documents first. If Lord should kindly permit me to refer to internal page number 2 of the award.
Yes.
Para 5.
Yes.
In this case, on behalf of the applicant, Renuka Devi has been examined. On behalf of applicant, Exhibit 1, CC of FIR, CC of charge sheet, Xerox copy of PM report. Exhibit 4 is pension intimation. Has your lordship got it?
Yes.
Exhibit 5 is DL of deceased. Exhibit 6 is ID of applicant. Exhibit 7 is PAN card, and Exhibit 8 is income tax return. Now, lordship may kindly take a note. Exhibit 4 is pension intimation. And just the previous page may kindly be seen. Last line, monthly income of the deceased was rupees 23,000 per month. Now, lordship, the income tax return with the deceased, which was brought on record, the date of accident is 10/5/2007. And my lords, the income tax return for the period 2005-6 was considered. And he was a pensioner. Deceased was a pensioner.
He was 53 years.
My lord, he had taken VRS from Tata Steel.
Okay.
This is the first aspect, my lords. Now, if lord should kindly turn to the internal page number 3 of the award. I'm just placing 4 lines from the top.
2,66,000.
My lord, I'm just placing 4 lines from the top first.
Yes.
So obviously, owner of the vehicle was driving it, which was overloaded. The deceased himself was driving. In this case, charge sheet has been submitted against driver of truck number, the present. In this case, there is one more peculiar fact. As per driving license of the deceased, he himself was driving the vehicle and the owner of the said vehicle. As per driving license of the deceased, which has been marked as deceased was professional driver. However, as per Exhibit 4, he was working in Tata Steel, and as per applicant, deceased was working as designer in Tata Steel.
Designer.
Designer.
So, where is the bar?
My lords, what case I'm trying to build up is, my lords, the deceased had taken VRS from Tata Steel. He was getting pension. And thereafter, he was driving the vehicle, which was overloaded. And he himself met with an accident on account of the collision. So, my lord, deduction, first of all, to the effect, this is a clear-cut case of contributing negligence because on account of overloading of vehicle. The second is the income with criminal has taken on the basis of IT returns of the year 2005-6.
What do you mean by overloading?
My lord, there were 9 persons which were sitting in the vehicle.
What is the vehicle?
My lord, the vehicle is Tata Sumo.
Tata Sumo, what is the seating capacity?
5+1. I'm sorry, my lord, total 5. 4+1.
Oh. Tata Sumo is more than 6.
My lord. Even otherwise, my lord, there were 9 persons.
It's rather, it should be, it is a 8-seater or 9-seater vehicle.
The claimant have not brought on record the registration document of the Tata Sumo vehicle, with the deceased was the owner and himself driving. The second is income tax return for the period of 2005-6 was taken into consideration for determining the amount of compensation.
Contributory negligence, you are pleading contributory negligence?
My lords.
What is the proof? You have also not appeared. How can you?
My lord, this is my humble submission.
Your submission cannot be.
My lord, even if there's the FIR which has been lost,
Merely by taking 9% in the vehicle will not give presumption that the vehicle was there was a negligence on the part of the driver.
My lord, the manner of the accident.
So that because of taking 9 passengers, the accident has occurred, and without
My lord, in
9
this case,
passengers, the
my lord, in
accident
this
is
case,
not
the
occurred.
tribunal has given a finding to the in my favor, but has only granted contributing negligence to the effect of 25%, my lord.
Be happy with that.
My humble submission, it ought to have been absolute negligence on part of the deceased. The second is, my lord, with regard to
What
income.
is the evidence of contributory negligence? I'm asking you.
My lord, the evidence with regard to the contributory negligence, because the claimant has not assailed that finding. So the finding is complete.
I'm asking you, what is the
My lord.
evidence? You are saying 50%. What is the evidence of
My lord,
contributory
my lord,
negligence?
the
Forget
FIR.
about the percentage first.
My lord, the FIR itself, my
What is
lord.
FIR? What is
My lord.
FIR?
Place कर देते हैं, my lord. The FIR, my lords, this is exhibit 1.
Yes, read it.
My lord, हमारा नाम राजेंद्र सिंह सो है। आज दिनांक 10/5/2007 के समय 8 बजे रिम्स रांची के सर्जरी विभाग के बेड संख्या पर जख्मी हालत में सर्जरी विभाग के बेड संख्या 16 पर जख्मी हालत में आप नामकुम थाना के दरोगा के समझ बयान देता हूं कि दिनांक 5/5/2007 को अपने गांव 16 में सुरेंद्र प्रसाद सिंह की लड़की की शादी में जमशेदपुर में भारा के सुमो J05QO491 से अपने पूरे परिवार के साथ घर गए थे। भारा का सिमो से घर गए थे तथा शादी का कार्य समाप्त कर घर का भी कुछ काम कर उस सुमो J16 से दिनांक 9/5/2007 को शाम के 3 बजे टाटा के लिए चले थे। आज दिनांक 10/5/2007 की सुबह करीब 5:30 बजे उस सुमो से जैसे ही नामकुम सैलरी कैंप के पास थे एक NH33 से गुजर रहे थे कि टाटा की तरफ से एक ट्रक नंबर 16 का चालक तेजी लापरवाही से ट्रक चलाते हुए आकर सुमो से आगे से धक्का मार दिया, जिससे सुमो का चालक, उसके भाई योगेंद्र सिंह, भाभी 16, भतीजा 16, नीरज कुमार सिंह, धीरज कुमार सिंह, रंजन कुमार सिंह, रवि सिंह गंभीर रूप से जख्मी हो गए। जख्मी हालत में हम सभी को जनता के सहयोग से पुलिस नामकुम थाना के रिम्स में इलाज हेतु लाकर भर्ती कराया। तो
What is there in the
आगे से
FIR?
धक्का मार दिया।
What is there in the FIR to conclude that there was a contributory negligence?
मतलब आगे से धक्का मारे, सामने से धक्का हो गया मतलब।
So
मतलब two conditions become material. There were persons which were seated in the sumo. First, there were 9 persons. The second is the head-on collision took place between the vehicles. So,
merely presence of 9% will not be enough to conclude conclusively that there was a contributory negligence.
Well, the tribunal has returned a finding with regard to the same said aspect and it has allowed 25% reduction.
Yes.
My humble submission is this should have been a minimum of 50%.
On what basis?
Well, in view of these two, had this been a simple...
What?
My lord, had this been a simple...
A truck came and dashed this vehicle.
My lord.
So?
My lord. Had this been a simple case where the vehicle was not overloaded, in that case, this would have been a different concept.
Is it your case that just because of overloading the accident had taken place?
My lord, the notice since was not just served upon us. My, this is, in the appeal, this is the case.
No.
In the appeal, this is the case.
In the appeal, you cannot make out a new case.
But since the notice was not served upon us, my lords.
That you have missed the bus.
My lord,
and you have missed the bus by deleting the prayer. So there is nothing to suggest that there was a contributory negligence. A contributory negligence has to be pleaded and proved, and by the party who is taking that ground.
My lord.
So there is no pleading and there cannot be a proof.
My lord, my humble submission with regard to the first is, even if my order 9 rule 13 application has been rejected, this is not under challenge. Still, this honorable court may look into the same because the interim order debarring me merges with the final award.
No. No.
It merges with the final award, my lords. But then, otherwise, what would happen, my lord? I pose a question to myself.
But you have already challenged that.
My lord.
You have challenged that. That was also dismissed, and you have accepted that dismissal.
My lords.
Not in this case. You have accepted that dismissal.
My lords, I cannot argue
Order 9
beyond
Rule 13 petition was filed. If a petition under Order 9 Rule 13 is dismissed, what is the remedy available to you?
my lord,
Order
miscellaneous application.
Order 43?
My lord, miscellaneous application should have been filed separately, my lord.
You have not. You have accepted that.
My lord, then may I just pray, my lord, that I may be permitted to file a separate miscellaneous application.
Sorry, Mr. Counsel. In an ex parte case, there are two remedies available to you.
My lords.
Either file Order 9.
My lords, I am getting what your lordship is indicating, my lord. I am getting that.
Reopen the case and contest. Number
My
2,
lord.
if you see that the judgment is such without your filing written statement, you can get benefit of the judgment, you straight away come and file an appeal.
My
There is
lord.
no
My lords.
straight away you have come and file an appeal after dismissal of the.
My lord, this I am conscious of the fact, my lord. This I am conscious of the fact, my lord.
So.
My lord, so far the other ground of is concerned with regard to income tax.
Yes, income.
The income of the deceased.
Yes.
Point number 8.
Yes.
The internal page number 3. Now I take up points for determination. Number 3. Are the applicants entitled?
How many days delay?
My lord, 407 days, my lord.
Because there is a delay of 407 days in filing this appeal. Next, learned counsel appearing on behalf of the appellant submits that the impugned award was ex parte, which was challenged in revocation case number 33 of 16. Full stop. The filed under Order 9 Rule 13.
My lord.
Filed under Order 9 Rule 13 of the CPC. He submits that by judgment dated, by order dated 20/4/2017, the said application was dismissed. Thus, thereafter only dismissed. Full stop. It is the case of the appellant that only after dismissal of the said application this appeal was filed, which consumed time. Full stop. The opposite party opposes the prayer. Full stop. Considering the submission and the fact that this appeal was filed after dismissal of the application filed and after dismissal of the application filed for setting aside the ex parte award, this appeal was filed. This IS stands allowed. Delay condoned. Is this case under the heading for admission? Call for LCR.
My lord. All right, my lord.
Have you satisfied the award?
My lord, I don't think so, my lord.
Don't satisfy it.
My lord.
It will be better for the claimant. The interest component will increase.
Definitely, my lord.
Yes.
In fact, I got the indication, my lord. I'll try to have a settlement also, my lord, if possible.
The case will be listed after 2 weeks.
My lord, definitely.
Claimants are appearing?
My lord.
Yes.
Notice.
There's this case after 2 weeks. In the meantime, the LCR should
My lord.
be received.
Serial number 20, MA number 299 of 17, Mr. B.C. Jha, for appellant, Mr. Jitendra Patil for respondent.
Lords, I have appeared for the claimants, Lords.
Yes, where is Mr. Jha?
Yes, Lordship. This case is purely on the ground of quantum, your calculation of quantum of the award, your Lordship. Lordship, in conventional head, 1,60,000 has been allowed, and income 50% has been increased for the future prospect, which is only 40% can be allowed, your Lordship.
What was the deceased? What was the income? What was the profession of the deceased?
Yes, Lordship. That is also in some disputes that may kindly be seen in the judgment, your Lordship, para 12, issue number 6.
Yes, yes.
Since it has already been established that the death of the deceased occurred due to road traffic accident, and therefore the Lordship.
How was he earning his livelihood?
Yes, Lordship. That is in para 12, your Lordship. It has been explained. Next paragraph, age. Age, it has come 35 years, Lordship. Next, income, your Lordship. Page 4, internal page 4 of the judgment, para 12. The plaintiff have pleaded in their claim petition that have you, your Lordship, got it?
Yes.
Yes. The plaintiff have pleaded in their claim petition that deceased was earning 12,000 per month from the vehicle. PW 1 to 3 have also stated in para 3 of their respective deposition that the deceased was earning rupees 12,000 per month from the vehicle, but they have neither proved the number of the vehicle nor the driving license of the deceased, and therefore this claim of the plaintiff is held not sustainable and in view of the facts and circumstances prevailing in the society and fluctuation in day-to-day work of the private worker, the daily income of the deceased held to be 200 rupees per day, and thus the monthly income comes to be 6,000 per month. And next page.
No wrong.
And next page, your Lordship, calculation.
Yes.
Income 6,000, 50% added for by way of future prospect. That should be 40% only as per the prima facie judgment, your Lordship. Because he was not in a permanent service, he was below 40 years, so 40% future prospect can be added. 1/4 correct deduction has been made, your Lordship, because the 6% are the claimants. Up to 6, 1/4 deduction is permissible. And in the loss of consortium, loss of care and guidance and funeral expenses, 1,60,000 has been paid. That should be 70,000. These two heads, it should be deducted, your Lordship. And after deduction, I have calculated it. After deduction, it comes to rupees 12,29,600.
How much?
It is 12,79,600 minus 50,000 under section 140. It comes 12,29,600. Whereas the tribunal has
it comes to as per you 12 lakhs.
It comes to as per my calculation, your Lordship, 6,000, then 40% future prospect, 2,400 added, 8,400 less 1/4, 2,100. It comes 6,300 into 12, 7,56,000. 75,600 into 16 multiplier, it comes to 12,96,000 plus 70,000, it comes to 12,79,600, your Lordship, minus 50,000, 12,29,600 is the final amount, your Lordship. Out of this amount, your Lordship,
12,29 or 79?
79, thereafter 50,000 deduction of 140.
12,79,000 as per you.
Total.
Before 50,000.
Before 50,000.
12,79,000.
12,79,600. And after deducting 50,000, 12,29,600.
So we need to say 1,75,000 rupees has been paid extra.
Yes, Lordship. And 14,06,000 has been awarded, and as per calculation, it comes 12,29,600.
So 1,75,000 has been paid extra.
Yes, Lordship.
Mr. Tripathi?
And one more thing, your Lordship. 23/7/18 order may kindly be seen. By this order, we were directed to deposit 16 lakhs rupees. And out of 16 lakh rupees, only 9 lakh rupees has been allowed to be disbursed, and 7 lakh rupees is remaining there.
That's the interest component was also there. Yes, Mr. Tripathi? He says 1,75,000 rupees has been awarded extra. Under the loss of consortium, care, guidance, funeral, it cannot be 1,60,000. And future prospect cannot be 50%. Mr. Tripathi? Switch on.
Lords, there are five dependents of the deceased, Lords. and all were dependent upon them, and
You just make out
definitely
your case in terms of
definitely.
you just make out your case in terms of the Pranay Shetty judgments.
Yes, in Pranay Shetty judgments.
It is clear that, Lordship, 1/3 should be deducted where the family members are 2 and 3. 1/4 where the family members are 4 to 6.
4 to 6.
And
Yes,
one-
yes.
My senior friend is absolutely correct as per the Pranay Shetty judgment.
Absolutely correct. His calculation is absolutely correct. 1,75,000 more you have been paid.
Yes,
So, what is your submission?
my submission, Lord.
Take instruction from your client.
Yes, absolutely.
If they are ready for less 1,75,000.
Yes,
If
Lord.
they are ready for how much? 12,70,000?
12,29,600.
No, 12,79,000.
12,79,000, Lordship. Then
Less
50,000.
the amount paid. Less the amount paid.
Lords, I will take a suggestion, Lords. Definitely.
Next week under the heading for orders.
Yes.
Next week under the heading for orders.
Lordship, next week, if any date may be fixed, Your Lordship, because I may be out of the station for 7 days.
After 1 week then?
And then in the first week of April, Your Lordship, 5 or 6.
Not too much. Okay, the first week of April.
Yes.
You take instructions.
Yes.
Difference of 1,71,000 and legally he is right.
Yes, I will suggest some more thing, Lords. Yes, I will take a step.
Under the heading for admission, serial number 21 with serial number 22, MA number 115 of 15 with MA number 169 of 15, Mr. Rajiv and Mr. Pramod Kumar Chaudhary for appellant in first case, Mr. DC for appellant in second case, Mr. Vishwanath Sahu, Mr. Rahul Sahu, Mr. Sanju Prasad, Mr. Kunal Chandra Suman for respondent in first case, Mr. Vishwanath Sahu, Mr. Atmanand Chaudhary for respondent in second case.
My Lord, I appear for the appellant in the first case, that is MA number 115 of 2015.
Okay.
My Lord, the limited scope, my Lord, in this appeal is that the multiplier, my Lord, applied by the learned court below, that to my humble understanding, my Lord, is erroneous. My Lord, the multiplier should have been, as per the judgment of the Honorable Supreme Court, that is, my Lord, 2009 6 SCC 121 Sarla Verma
Multiplier.
versus the.
What is the multiplier applied?
My Lord, that is 13.
It should be as per the age of the deceased.
Yes, my Lord, it has been applied as per the age of the mother of the deceased.
It is erroneous. It is wrong.
And therefore, my Lord, the multiplier should have been 18.
And so far as the other income, you have no
My Lord,
objection.
I have no objection, my Lord.
Only the multiplier. This appeal has been filed only for the purpose of multiplier.
No, Lord. We have also filed
I'm
an appeal.
asking Mr. Rupesh Singh. I'm asking Mr.
Okay,
Rupesh
yes.
Singh.
Yes.
His grievance is
Yes.
only the multiplier.
My Lord.
And what is your grievance, Mr. Jha?
Yes, Lordship. His grievance regarding to multiplier is correct, Your Lordship. His income has been, future prospect has been given 50%, which should have been 40%, Your Lordship. In conventional head, 1,25,000 has been awarded. It should have been 70,000 only, Your Lordship. And interest 9% has been allowed from 17/1/2011, and failing which 12% penal interest, Your Lordship. It is not permissible, Your Lordship.
Yes, Mr. Rupesh Singh, what do you have to say?
My Lord, so far as the interest component is concerned, my Lord, if the insurance company would have complied with the order of the learned court below, my lord, it could not have arisen. Now, my lord, when the award is only being contested.
Just a minute. The statutory period of appeal is 90 days. How could the court say that pay it within 1 month, otherwise we will impose penalty of 12%?
My lord, that is there.
Tell me. So,
My lord, I cannot dispute that.
So that goes 12% goes 9%. I am not interfering.
My lord.
It should be 9% throughout. Now, what about the conventional heads?
My lord, the monthly income has been decided at 8,000.
Just let me see. 8,000 per month.
Yes, my lord.
Just let me make a little calculation. 4,000 after deducting 50%. 12. What is the age of the deceased?
21 years.
Mr. Jha.
Yes, Lordship.
As per your calculation, 40%, 70,000. It comes to 12,79,600. With 18 multiplier.
Yes. Yes, yes, Lord. Yes, sir. 12,66,000.
12,79,600 most probably.
Now, see, 4,000, 40%.
Let us calculate 4,000.
Yes.
Into 12 into 18 equals to 8,64,000. Is it not?
I have calculated this in some other way also.
No, it is 4,000 into 12 into 18.
Yes. Yes, Lord.
4,000 into 12 into 18. Then add 40%.
Yes, Lord.
Into 140%. So it is 12 lakh 9,600.
600. Plus
Yes.
70,000.
12 lakh 79,600.
Yes, Lord.
So, Mr. Rupesh Singh.
My lord, I bow down to my lord.
plus 9% interest as awarded.
Yes, Lord.
Yes.
That is the correct position of law, Your Lordship. At present, this is the position.
Then, what is the judgment where it has been held that even if the deceased, the multiplier of the deceased will be
My lord, that is 2009, volume 6 SCC,
yes,
page 121, relevant page 139.
that sometime there was a judgment that the age of the parents will be taken, but that has been subsequently.
Yes, my lord. It has considered several judgments, my lord, prior thereto, and then finally gave the, my lord, chart by the Honorable Supreme Court as to which multiplier is to.
As per Sarla Verma, Your Lordship.
Mr. Rupesh Singh, so it
My lord.
is 12 lakh 9,600, 12 lakhs
Yes, my lord.
9,600 plus 9%
Yes,
interest.
my lord.
I don't think so you will have any grievance.
No, my lord.
Mr. Jha also cannot have any grievance.
No, sir, Lordship. That is the correct law. So, and less 50,000, Your Lordship.
Yes, yes. Less 50,000.
That is the correct law, Your Lordship. Only I can pray, Your Lordship, that nowadays interest component is 9%, Your Lordship, 9% interest. Even if we all are based on the judgment of Sarla Verma, Your Lordship. Sarla Verma judgment, I am reading last line, Your Lordship. 51. We allow the appeal in part. Accordingly, the appellants will be entitled to set sum of rupees 1,65,246 in addition to what is already awarded, with interest at the rate of 6% per annum from the date of petition till date of realization. In all cases, we are relying upon the Sarla Verma, Your Lordship, and Sarla Verma has been confirmed by the Honorable Supreme Court, Your Lordship, in Pranay Sethi case, Constitution bench. So this preposition of law.
Yes, Mr. Rupesh Singh.
My lord, my submission to the interest component is that, my lord, that judgment of Honorable Supreme Court is of the year 2009, my lord. With the passage of time, the economic inflation, and keeping these aspects into consideration.
The passage of time, the interest rate has gone down.
Gone down.
No, my lord, the expenses for the life, my lord, daily.
Can't help it. The interest rate has gone down.
Well, interest rate on the deposit, my lord, but the expenditure for the life, to lead a life, my lord, that taking that into consideration, economic inflation.
That cannot be.
The economic inflation aspect may kindly be considered, my lord.
So I make it 8%.
Oblige, my lords. Oblige, my lords.
Like you heard. 2009, volume 6, 121. Yes, 139. That is page number 139.
Yes, my lord.
Both these appeal are taken up together and is being disposed of at this stage itself with the consent of the parties. Next paragraph. Miscellaneous appeal 115 of 2015 has been filed by the claimants praying for enhancement of the compensation amount, whereas miscellaneous appeal 169 of 50 has been filed by the insurance company taking a plea that the quantum of compensation is exorbitant and is not in accordance with the judgment of the Honorable Supreme Court and has not been computed in accordance with the law laid down by Honorable Supreme Court.
And contributory negligence also. And contributory negligence also, which has been decided against us.
And then and also taking a ground that there was a contributory negligence on the part of the deceased, which has not been properly considered by the tribunal. Next one. Both these appeal arises out of a judgment and award dated so and so, passed by so and so, so and so. So and so. Next paragraph. The deceased, aged about 21 and a half years, died in a motor accident as he was going from Ranchi to Ramgarh in his motorcycle bearing registration number JH01X5109. Full stop. While the deceased reached Chutupalu Ghati on NH33, a truck bearing registration number BHM 7862, being driven in a rash and negligent manner, dashed the motorcycle, resulting in several injuries. Which led to death of the son of the claimants. The deceased was a bachelor and was earning 8,000 rupees per month from tuition and other mechanical work. Full stop. The claimant being the parents of the deceased, filed the claim application, including the insurer of the offending truck and the owner of the truck. Full stop. Next paragraph. Next. The insurer and the owner appeared before the tribunal?
Yes, Lordship.
Yes, my lord. Owner appeared.
Appeared.
OP1, Motor Mineral Corporation.
Yes, my lord.
In page 2 of the judgment.
And they filed their respective written statements. The fact that the offending vehicle was insured with the National Insurance Company Limited was not disputed. It was also pleaded that the offending truck was roadworthy and the driver also had a valid driving license to drive the same vehicle. The insurance company had taken a plea that the deceased was also liable for the said accident, as he was also negligent. Next paragraph. On the pleadings of the party, the tribunal framed 7 issues. Which are as follows. Quote. The tribunal thereafter, on the evidence and on the oral and documentary evidence, held that there was no breach of the terms and condition of the insurance policy, and it is the driver of the truck who was negligent. The tribunal has also held that neither the owner of the vehicle nor the insurer of the vehicle had come up with any oral or documentary evidence to establish that the accident occurred due to the negligent acts of the motorcycle. The tribunal held that in absence of any evidence, it cannot be concluded that there was a contributory negligence. So far as the quantum of compensation is concerned, the income of the deceased was assessed at rupees 8,000 per month. Full stop. Out of the aforesaid amount, since the deceased was a bachelor, 50% was deducted on account of personal expenses. Full stop. The tribunal awarded an enhancement of 50%. The tribunal enhanced the amount by 50% on account of future prospect, within inverted commas, future prospect. Let's start. The multiplier of 13 was applied full stop. Under conventional head, the tribunal awarded 25,000 towards funeral expenses, 1 lakh towards loss of estate, love and affection. And thus held that the claimants are entitled for a compensation to the tune of rupees 10,60,000. First up. Interest at the rate of 9% was awarded from the date of filing of the application. Full stop. The tribunal directed to satisfy the award within a month, failing which the interest rate was enhanced to 12% per annum. Next one. Agreed by the aforesaid judgment and award, both the claimant and the insurance company has challenged the said award. Full stop. The grounds of challenge and the arguments of the learned respective counsels have already been noted in paragraph so and so above. जो आगे वाला लिखे हैं. Full stop. I have heard the counsel for the parties, appellants in both the appeals, and have gone through the judgment. The issue involved in this appeal is as follows. Number one, whether there was contributory negligence on the part of the deceased. Number two, whether the quantum has been correctly assessed by the tribunal after applying a correct multiplier of 13. Number three, whether the tribunal has granted an excessive amount under conventional head, excessive amount of compensation as under conventional head. And number four, whether the interest rate Interest at the rate of 9% and 12% awarded is on the much higher side. So far as the first issue is concerned, which relates to contributory negligence is concerned, the law has been settled by the Honorable Supreme Court in the case of so and so versus so and so, wherein the Honorable Supreme Court has held that the party who is raising the point of contributory negligence must plead and prove the same. In this case, it is the insurance company who has raised the aforesaid issue. In the case of, in the case 2014, Volume 4, SSC, page 551. Prove the same, लिखा है ना? It is necessary to quote paragraph 10 of the aforesaid judgment. In this case, the insurance company has raised the issue of contributory negligence. Where is your written statement, Mr. Johnson? Yes. The insurance company in paragraph 5 of the written statement has pleaded the fact of contributory negligence, pleaded contributory negligence on the part of the deceased. They have only mentioned that the matter relates to contributory negligence which requires to be ascertained.
In para 8 also, in para 8 also.
What is the contributory negligence in para 8?
Para 8, last line, sir, that the insurance company of motorcycle number such and such has not been made necessary party to party despite of necessary.
Para 7. That is para 7.
No.
But that is not a contributory negligence.
Insurance company in paragraph 5 had pleaded that contributory negligence on the part of the deceased. They have only mentioned that the matter.
They have only pleaded that. Mentioned they have only pleaded. They have only pleaded. Now, no detail foundation of fact has been mentioned as to how one can infer that there was a contributory negligence on the part of the deceased. So far as yes,
my lord, page 4 of the award.
Just a minute.
I'm sorry. On the aspect of pleading by the insurance only.
So far as the proof is concerned, I find that the insurance company has not produced any oral or oral evidence to prove that there was contributory negligence on the part of the deceased. On the contrary, it is the case of the claimant that the offending truck was being driven in a rash and negligent manner, which dashed the motorcycle, resulting in the accident and death of the deceased. It is the consistent case of the claimant that just because of the rash and negligent act of the truck, the offending truck, the accident has occurred. Charge sheet was submitted against the truck driver. Further, it is an admitted fact that in the criminal proceeding, the charge sheet was submitted against the driver of the truck, showing him to be rash and negligent. Thus, I find that there is no evidence in support of the contention of the insurance company that the deceased had contributed in any manner towards the accident. In absence of any evidence, I find no illegality has been committed by the tribunal in dismissing the plea of the insurance company that the deceased also contributed towards the accident. Next paragraph. So far as the issue number 2 is concerned, क्या था issue number 2? Friend किए थे? Multiplier. Uh, 2 is concerned, the quantum needs to be ascertained. First up. As per the Motor Vehicle Act of 1988, the claimants are entitled for just and fair compensation. First up. In this case, the tribunal assessed the monthly income of the deceased to be 8,000 rupees per month. This assessment has not been challenged by any of the parties. The insurance company in their appeal has challenged the enhancement of 50% by way on account of future prospects.
With your lordship permission.
Yes.
Lordship has stated that 8,000 rupees, which has not been challenged by the parties. In memo of appeal, we have taken this ground, your lordship.
The insurance company has challenged the quantum, on the ground that the income of the deceased cannot be 8,000. But they have not brought any material on the record to prove contrary. On the basis of the evidence led by the claimant, wherein the PW1, who is the mother of the deceased, in paragraph 7 has stated that the deceased was earning 8,000 per month. Full stop. There is nothing in the cross-examination to disbelieve the aforesaid statement. Thus, the tribunal has correctly assessed the income of the deceased as 8,000 per month. Full stop. The insurance company the insurance company has challenged fixation of future prospect at the rate of to the tune of 50% of the income. Full stop. according to the insurance company, lawyer of the insurance company, according to the learned counsel, since the deceased was self-employed, in terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others, the future prospect enhancement on account of future on the ground on account of future prospect should be to the tune of 40% of the salary. The Honorable Supreme Court in the case of Pranay Shetty Supra, in paragraph
59.3.
Point
59.3.
3
Yes, Lord.
has concluded that 59.4 has concluded that in case of a self-employed, if the deceased is below 40 years, 40% enhancements should be granted. Thus, I find that the tribunal has erred in awarding compensation to the tune of enhancement to the tune of 50% in place of 40%. Thus, I hold that the claimants are entitled for an enhancement of 40% on account of future prospect. Also, subparagraph. The insurance company has also challenged the award of compensation under conventional head. First up, the tribunal in this case has awarded 25,000 rupees 25,000 towards funeral expenses and 1 lakh towards loss of estate, love and affection. Loss of estate, love and affection. First up. This issue has also been settled by the Honorable Supreme Court in the case of Pranay Shetty. In paragraph 59.8,
59.8.
it has been held that under conventional head, the reasonable amount would be would be 70,000. Thus, this court holds that the claimants are entitled for an amount of 70,000 on account of under conventional head. Next. The next issue which is under consideration is multiplier. Next issue. Now the question which has been raised by the claimant in their appeal is the multiplier, is the application of multiplier. The tribunal has applied multiplier 13 as a multiplier. Admitted case of the parties is that the deceased was aged about
21 and a half years.
As per the judgment of the Honorable Supreme Court rendered in the case of Sarla Verma, which has been followed by the Pranay Shetty, which has been followed in the case of Pranay Shetty, so far as application of multiplier is concerned, the multiplier which has to be applied will be according to the age of the deceased, even if the deceased is a bachelor. Thus, thus considering the aforesaid two judgments, and considering the age of the deceased, in this case, the multiplier of 18 should have been applied, and not 30, and not 30. Full stop. Next paragraph. Next together. Point.
Interest.
Full stop. Now the question which falls for consideration is the rate of interest. The tribunal has awarded interest at the rate of 9% per annum from the date of admission of the case. That is 17/1/2011 till payment. Also, the tribunal directed to make payment within 1 month from the date of receipt of the copy of the judgment, failing which the interest rate was enhanced to 12% per annum. थर्ड में क्या है? कन्वेंशन रेट को उधर भेज दीजिएगा जो बनाया है, सब पैराग्राफ, make it a separate paragraph. The convention. Let's start. Section 171 of the Motor Vehicles Act provides for grant of interest. Motor Vehicle Act of 1980. You always give the full name of the act along with the year. It is provided in the aforesaid provision that the interest, the simple interest, is to be granted from a date, but which should not be prior to the date of filing of the application. In this case, the application was filed. In this case, I find from the lower court records that the application was filed on 8/12/2010, which was admitted on 17/1/2011. The tribunal granted interest from 17/1/2011. First up. The award of interest at the rate of 12% after expiry of 1 month. This cannot be justified. As per section 173 within bracket 1 of the Motor Vehicles Act of 1988. The statutory period for filing the appeal has been fixed at 90 days. Full stop. When the statutory period has been fixed as 90 days for filing the appeal, according to me, the tribunal could not have directed the appellants and directed the insurance company to pay the amount within 90 days, within a month, and impose an interest at the rate of 12% per annum if the amount is not paid within 30 days. This part of the award awarding 12% interest is set aside. Good start. It is the contention of the learned counsel appearing on behalf of the appellant that in the judgments of the Honorable Supreme Court, that is in the case of Pranay Shetty and Sarla Verma, what is the interest rate given in the Pranay Shetty case?
Lordship, Pranay Shetty is silent about it, Your Lordship, but
In the case of Sarla Verma, which has been heavily relied upon
yes, Lordship.
on several issues by the subsequent judgment in the case of Pranay Shetty, 6% interest has been awarded. It is his contention that in this case also 6% interest be awarded. The counsel appearing on behalf of the claimant submits that the price, considering the rise in the price index and the inflation, and the fact that the deceased was the only child.
It has not come, Your Lordship, anywhere. It has not come.
And the fact that the parents have lost their support, who was the earning member of the family, comma, the rate of interest may not be interfered with. Considering the rival submission, I am of the opinion that the rate of 9% interest is on the much higher side, considering the scenario, financial, the fiscal scenario. Further, considering that the accident had occurred in the year
2010. 33/11/2009.
2009.
Yes, Lordship. And case was filed in 8/12/2010.
And the interest rate prevalence. But this court is of the opinion that it would be suffice if 8% interest is awarded to the claimants on the compensation amount, from the date of admission, from the date of filing, from the date of filing, from the date of
only 1 month difference.
till the amount is paid. Next one. Now, on basis of what has been held above, the quantum of compensation needs to be recalculated, which will be as follows. Okay. Monthly income 8,000 multiplied by less 50% deduction on account of personal expenses equals to 4,000. 4,000 into 12 into 18 equals to 8,64,000. Add 40%. Equals to so and so. Add 40% within bracket, future prospect equals to so and so. Add 70,000 on account of so and so. So thus, according to this code, just and fair compensation would be so and so. This amount will carry an interest at the rate of 8% per annum from the date of filing till the amount is paid. Yes, how much money has been paid?
Lordship, under section 140, order dated 6/1/2012, 50,000 was allowed.
Only 50,000. Only 50,000 has been paid. Full stop. The insurance company is directed to pay the entire amount along with interest after deducting rupees 50,000 50,000 which has already been paid under Section 140 of the Motor Vehicle Act, in terms of Section 140 of the Motor Vehicle Act. Full stop. This same amount should be paid within 10 weeks, to the claimants. Stop. With the aforesaid observations and findings, both these appeals are partly allowed.
Statutory amount.
Full stop. The statutory amount deposited by the insurance company in MA number 169 of 2015 be refunded to the insurance company. What are the IAs?
Lord, IAs are infrastructure. It was for implement of the successors of the company whose vehicle was flying. That has been allowed.
No, for early hearing. Two IAs has been filed for early hearing.
No, one IA in your case, Mr. Yeah, let me see.
That has been allowed, Your Lordship. And last occasion, I have included 2 persons as a party, subsequent partners of the.
Subsequent partners. Those
Yes,
IAs allowed.
Yes, Lord. 2 IAs are.
Huh?
Perhaps for early hearing.
IA number? 00? 11009. 11009. And in the second case? 11010. There is no 11010. This is a partnership firm, Moti Minerals.
Yes.
Mr. Babu, you are appearing?
Yes, my lords, I am appearing, my lords.
This is a partnership firm.
Yes, my lord, it is a my lords company incorporated under the Companies Act, my lords.
It's a company.
Yes, my lord.
No, partnership firm.
So sorry, my lord, it's a partnership firm, my lord. I might that correct.
You are appearing on behalf of the present partners.
Newly added partners. Last order, you kindly be sent.
IA number 1, separate page. IA number 11010 of 2019 in MA number 169 of 2015. This IA has been filed to impede the present and existing partners of Mrs. Moti Mineral Corporation. Full stop. Moti Mineral Corporation is the owner of the offending vehicle. Full stop. After reconstitution of the partnership, now the partners are
They have already implemented last date only, 8/3/2022.
My lord, the name of the partners are my lord, it's one Mr. Santosh Kumar and the other is
8/3/2022. 8/3/22. Only 15 days back.
8/3/22 order.
And I have already implemented on the same day, Your Lordship, by red pen, Your Lordship, 3A and 3B.
Yes, it has been added. लिखे दो full stop. The existing partner has already been added by incorporating their name. That is in the different case, incorporating their name in MA number 169 of 50. Thus, IA number 11010 of 2000 so is also disposed of. What is the other one? There in MA 115, IA number 11009 of 2019. In view of the order passed on 8/3/2022, this IA also and the necessary correction 22, this IA is also disposed of. Separate sheet में main order के बाद में आएगा.
And my lord, one humble submission, my lord. My lords have directed to make the payment within 10 weeks, my lord. If some consequences, my lord, may be prescribed in the event the payment is not made.
Interest, you will get the interest. You can file an execution case. You can file a certificate proceeding for recovery.
My lord.
What more? Tell me. There's a procedure to recover the amount.
My lord.
Initiate a proceeding under the Public Demands Recovery Act or file an execution proceeding before. Get it executed. Is the serial number? Within 4 minutes, the admissions. Finally, the cases cannot be disposed of.
Well, I don't think this will be disposed of within 4 minutes.
I also don't think so. Let it be.
That has not come, my lord. Let it be called for.
All right, let it be called for. I'm ready. I'm ready.
What is not there?
I am not aware, my lord, whether it has.
No, my lord, LCR was called for by your lordship's order on 15/1/2022, 2020.
23 and 24. Yes, LCR is there.
Yes, my lord.
So it cannot. It will be in the list. It's not taken up.
Yes, I'm ready. Let him file. Let my learner his case is the first. I'm ready.